Good afternoon, everyone. This is the Standing Committee on Citizenship and Immigration, meeting number 60, Monday, November 19, 2012. We are studying, this meeting is televised. We're studying Bill C-43, which is an act to amend the Immigration and Refugee Protection Act. We have two witnesses before us today. The first is the Ontario Council of Agencies Serving Immigrants, represented by Amy Casapalai. Every time you come here, I pronounce it wrong, and I'm sorry. You'd think I'd know. And Francisco Rico Martinez. Good afternoon to both of you. And we also have Jacques Shore, who's a partner with Gowlings, which I assume is the law firm. Good afternoon to you too, sir. We will let you go first, Mr. Shore. You have up to 10 minutes to make a presentation.
Thank you very much, Mr. Chair. Good afternoon, and I thank you for inviting me to appear before this distinguished committee today. These remarks are presented to the committee in memory of my cousin Lily Bergstein, who, along with her husband Solomon Bergstein, witnessed the atrocities of the Second World War. Il me fait plaisir d'être ici cette
I am very pleased to be here this afternoon to support Bill C-43 in principle. I would like to take this opportunity to commend the government for tackling this difficult issue and for proposing some essential and long overdue changes. With some amendments, I am confident that Bill C-43 can improve national security, public safety, and ensure the fair treatment of non-citizens.
I'm very pleased to be here this afternoon to support Bill C-43 in principle, and I commend the government for tasking this difficult issue and making these changes which are long overdue. I would like to concentrate my opening remarks today on three specific measures. First, I support Clause 24, which removes the appeal rights for persons convicted of crimes and sentenced to imprisonment for 6 months or more. This will speed up deportation of those convicted of serious offenses. Criminals should not slow down the Canadian justice system by relying on years of appeals and giving them the opportunity to reoffend. This is not to say that a person should be automatically inadmissible to Canada if they have committed a serious crime. There is already a safety valve in the system to ensure that each person's individual circumstances are taken into account. Under Sections 25.1 and Sections 25.1, subsection 1, of the current version of the Immigration and Refugee Protection Act, the Minister may allow a person to stay in Canada even if he or she has been deemed inadmissible. This effectively operates to prevent injustice within the system. Bill C-43 maintains this important power. This brings me to my second point. Clause 18 amends Section 42 by adding the criteria the Minister may take into account when deciding if certain persons should be allowed to stay in Canada. This clause only applies to persons deemed inadmissible because of a security risk, because of human or international rights violations, or organized criminality. As drafted, the Minister would only be permitted to assess national security and public safety considerations when exercising this discretion. I believe this is appropriate, as undesirable criminals should not be permitted to linger in Canada. In exceptional cases, the Minister will, I believe, in any case, still be able to determine if a person may enter or remain in Canada by considering additional factors in the context of the words in the proposed Section 42.1, subsection 3, which provides, I open the quote, but in his or her analysis, that being the Minister, is not limited to considering the danger that the foreign national presents to the public or the security of Canada, close quote. I am apprehensive of the potential impact that this legislation could have on permanent residents who have spent most of their lives in Canada. I believe that those living in Canada who are permanent residents must value and recognize the privilege of living in our country. One may ask, how can someone with no real connection to their country of origin be deported? Other witnesses have expressed views, and members of this committee have raised their concern on this question. However, I must conclude that with this privilege of permanent residence must also come the responsibility to be law-abiding and the will to make a positive contribution to our society. While the ability of the minister to exercise discretion in such cases is important, consideration should also be given in another vein, to implement measures to prevent this sort of situation from arising. Perhaps it is time to consider instituting a program to encourage good citizenship, which would also motivate long-time permanent residents to apply for citizenship. This could help prevent the unfortunate cases where young permanent residents become misguided and engage in unlawful activities. This could also ensure that they are aware of the risks if they lack citizenship, often due to the neglect of their parents or guardians. It is the right time to re-emphasize Canada's Citizenship Guide and its reference to Canada's 4 pillars: freedom, democracy, human rights, and the rule of law. Our Canadian values should be viewed as paramount and to be emulated in the behavior of those who seek to live in Canada as permanent residents and those who seek to become Canadian citizens. My third point also deals with ministerial discretion. Specifically, I would like to discuss Clause 8, which gives the minister the power to declare a person may not become a temporary resident. Bill C-43 allows the minister to use his discretion if he or she is of the opinion that it is justified on public policy considerations. I believe this is a necessary provision. There are people who should not be allowed to come to Canada, who nevertheless do not match any of the inadmissibility criteria established in the Immigration and Refugee Protection Act. Bill C-43, if passed, could prevent people from coming to Canada who have demonstrated track records of blatant lack of respect of our society's cherished values. The minister has proposed guidelines for how to exercise this power. These indicate that individuals who promote terrorism, violence, or criminal activity would be prevented from visiting Canada, as well as certain foreign nationals from sanctioned countries or corrupt foreign officials. These guidelines respect the need for certainty and restraint in the use of a discretionary power. In line with this principle, I would suggest that the guidelines be incorporated into the text of Bill C-43 itself. The current use of public policy considerations in Clause 8 is quite vague and could be clarified. This would result in 3 key benefits. The first, it would give guidance to the decision maker, the minister. Second, it would provide clarity enabling the public to fully understand the law and its stated criteria. And third, it would give a potential judicial narrowing of the scope of the ministerial power. Australia has adopted a similar approach. In the Australian Migration Act of 1958, the minister is given discretion to refuse or cancel a visa based on very specific grounds. For example, this power can be exercised if there is a significant risk that the person would incite discord in the Australian community or would vilify a segment of the Australian community. This provides certainty and transparency and ensures that the objectives of the Act are met. Canada can reap the same benefits by specifying the factors to be considered by the minister in Clause 8. In summary, ladies and gentlemen, Bill C-43 is a step in the right direction. It will prevent criminals from taking advantage of our overly generous appeals process. However, I would recommend amendments to clarify the rules of ministerial discretion to justifiably refuse temporary resident status. With some minor changes, this bill could advance Canadian immigration law in a manner that serves to protect Canadian citizens and instills fairness in our immigration review process. I thank you, honourable members of this committee, for giving me the time to speak with you today. Merci beaucoup.
Well, thank you, Mr. Shore. And now, Ms. Casapalai and Mr. Rico Martinez, you have between you 10 minutes. Thank you for
Thank
coming.
you, Mr. Chair, committee members. Thank you for inviting us to share with you our views today on Bill C-43. I will start off with an introduction and then hand it over to my colleague, Francisco, here. Francisco is also OCASI's Toronto Regional Director, and he is here in that capacity. We would like to focus our presentation on the impact on children and youth, particularly children and youth from racialized communities. We are very concerned about Section 24 of Bill C-43, which takes away the right of appeal for a permanent resident who has committed or was convicted of a crime, punishable by a sentence of 6 months. Canada's visible minority population was over 5 million in 2006. That represents 16.2% of the total population. Canada's racialized population is younger than the rest of the Canadian population. And the recent census numbers from Stats Canada show that the prison population grew by 17% between 2006 and 2011. In December 2011, Canada's correctional investigator said he was concerned about the sharp increase in the number of black inmates in federal prisons over the past decade, up about 50%. And statistics on the disproportionate incarceration numbers of black and Aboriginal individuals are not easy to find. The most recent set of comprehensive figures that we could find were from a 2004 study by Corrections Canada, which confirms that black offenders are overrepresented in prison, while Caucasian and Asian offenders are underrepresented relative to the general population. And visible minority women are also overrepresented as compared with Caucasian women. The Corrections Canada study also found that visible minority offenders tend to be younger. The study also found that they were at a lower risk to reoffend. And now I'll hand it over to Francisco.
And we are basically focusing in this in youth and racialized youth, because it's the people that we serve in the different settlement organizations and in community-based organizations that we have, and have been an issue that have been identified by our members. In 2010, Toronto started an investigative series on Toronto policy data, on police data for the period of 2003-2008 found that black men ages 15 to 24 are stopped and documented 2.5 times more than white male the same age. The finding echo a similar analysis of data than the Toronto Star did conducted in 2002. The overrepresentation of visible minorities in the prison system is rooted in factors of poverty, economic inequality, and historical prejudice. They include the over-policing of youth black men, a practice that results in racialized profiling. The existence of racialized profiling by police is well documented. It has been acknowledged to different degrees by various police services in Canada. The police chief in Kingston in 2005, for instance. I have a problem with that term. Racialization of poverty have been growing in Canada, including among the working poor. Racialized individuals do not have the same access to the labor market as everybody else. And this is well documented in recent reports of Canada Color Code labor market published by the Canadian Centre for Policy and Alternatives. In their study, Roots of Youth Violence, Rob McCurtry and Elvin Curley have said that while poverty does not lead to violence, that it can be one of the factors it plays. They said poverty without hope, poverty with isolation, poverty with hunger and poor living conditions, poverty with racism and poverty with numerous daily reminders of social exclusion can lead to the immediate risk factors for violence. They note that the lack of investment in services for those affected by these circumstances will have a deep impact in young people, leaving them with the few choices for their day-to-day needs, even such a need as quiet place to do, even to have access to a quiet place to do a homework. They know that these challenges can be exacerbated for those who have issues with language and cultural differences. Section 24, in specific, of Bill C-43, we have unintended and disproportionate impact on black and other racialized permanent residents, particularly youth, a population that has been historically disadvantaged in Canada and is already subject to routine suspicious scrutinies, negative stereotyping in the media, and is often faced with longer sentences. Corrections Canada experience with visible minority offenders is described as a following in the study mentioned earlier. Visible minorities offenders seems to be less entrenched in a criminal lifestyle than Caucasian offenders. They tend to have less extensive criminal histories and incarcerate less often for offenses against the person, and are lower in the risk and need than Caucasian offenders. They also tend to have higher level of education, less unemployment, and are less often single. The study notably concludes that these circumstances may help in rehabilitation. Bill C-10 has now become a law and has introduced a minimum sentencing. It will mean that even some nonviolent crimes will carry a sentence of 6 months, making sure that those permanent residents will then be deported from Canada. Those who are subject to these provisions can be deported regardless of how long they have been living in Canada. They will not have the right to appeal. They will not have a consideration of the circumstances of the offenses and potentially rehabilitation, no consideration of the length of time they have living here, ties to families or tied to a community. Individuals who have lived all their lives in Canada, particularly those who come as an infant or as a young children with lost families, friends, and communities when they are deported to a place they barely know or remember from before. They will have no family or community connections over there. Unlikely Canadian citizens, permanent residents will be punished twice for committing a crime. We urge you seriously rethink this bill, particularly this severe implication for young, visible minority Canadian residents, and to rethink about the, and we strongly encourage you to, we encourage you and recommend that Section 24 is withdrawn, allowing the right to appeal to stand. We also encourage you to ensure that young Canadian residents are fully informed of the impact of the Bill C-43 through avenues such as school, the curriculum in the schools, as well as other opportunities and campaigns, because this is going to have a serious impact in the communities that we serve. Thank you very much.
Thank you, sir. We will now have some questions from Ms. James, who's first.
Thank you, Mr. Chair, and thank you to our guests. Some back for another time. I just have to, I'm going to ask a couple of questions to Mr. Rico Martinez first. You've said that we need to rethink this bill specifically because of young, visible minority residents. I believe I wrote that down correctly. Mm-hmm. I'm just wondering, because you seem to be indicating that there's an out of balance in our federal penitentiary system, and I'm just wondering whether you're making excuses for people who commit crime. When you say that we need to rethink it because of a specific group, I just have a bit of problem with that, because you said because they don't have free choices of where they have few choices of where they can do homework. Maybe their language or cultural differences are different. Maybe their skin color is different. I just want to let you know that I know lots of people who fit those categories, and they do not commit serious crimes. So I'm just wondering why you substantiate your viewpoints based on those specific things, why you're against this bill. That's the problem that I have with your statement. So I'm just wondering whether you're making excuses for people who commit crimes, because, again, lots of people who fit those descriptions, have few choices, do homework, maybe come from a background where they're not, wealthy, language or cultural differences. Why you think we need to make excuses for people who commit crimes?
First of all, it's not my opinion. I was quoting the studies from which we took this information. So even though we are not experts in all the penitentiary and the overpopulated and all the situations over there, we did our research to show you that the population that we serve in our agencies, community-based organizations, they are racialized communities, and they a lot of them face a lot of isolation and a lot of discrimination and many other barriers, poverty, etc. I serve, and the majority of people that I serve, they don't have a problem like this. But once in a while, there is a problem of a youth, of a person that make a mistake. And we are not talking about the crime. We are talking about that particular individual that need not to be removed from Canada, need protection, need education, need many other things that we can provide here that they won't have over there. Plus, we are talking about that they are not they are the tendency to be rehabilitated as a one mistake is one of the areas that we want that you focus on. And we are just asking, we are just asking to give them the chance.
I've got my answer, but I'd like to ask more questions in relation to that.
I think she wants to ask you another question, Ms.
So I understand that you're saying you base that based on studies, but again, a study that says there might be, a disproportionate or whatever isn't a reason to excuse people who commit crimes. So I'm just going to leave that at that. I'm going to direct some of my questions over to Mr. Shore now. I saw in your bio, and you did mention it earlier, that you actually were co-lead counsel to the Air India Victims Families Association with regards to the Air India bombing.
With regard to the inquiry of
Yeah,
John
that would have
Major.
been something to be involved with. So I commend you for doing that. And actually, I was going to ask you if you've talked to victims groups or victims of crime, and I suppose that probably answers my question. But I'm wondering if you could speak to that, what the impact people who are not Canadian citizens who have come to Canada who commit a serious crime, what the impact it is onto those families, the victims, the families of the victims themselves, because sometimes the victims are no longer here, they're not alive.
Absolutely.
So I'm just wondering if you can speak to that, what the impact is on Canadians when something like this happens.
Thank you, Ms. James. My comments would be observational in a sense. While I have had the chance over the years to work with a number of groups and organizations that address issues on behalf of victims of crimes, which also includes, I should say, the Canadian Coalition Against Terror being one of those. I think there's a sense that there's a frustration that the system is not working when you look at individuals who have been victims of crimes and when you see potential for reoffenders by those who are here in Canada but do not do what is necessary to respect the system, to engage in the system in a meaningful way, as I've shared in my remarks. I have come across, certainly as my colleagues here today on the panel have said, there are outstanding immigrants that come to Canada. We are a nation of immigrants. But I do think that there is a sense of a responsibility that individuals that come to Canada as permanent residents do have. And when you look at those who are victims of crime, and in the specific instance, as you mentioned, Ms. James, where I'm dealing with just the tragedy post-Air India bombing, where you have families that are there, and we know very well that there have been individuals that have committed heinous crimes and are here. Our system hasn't been able to actually address it in the way they would want. And I think this is, again, a demonstration of the frustration, which is why I applaud the government for taking this step.
Yeah, no, I noticed that in your, I listened to your opening remarks, and you did indicate that you agree with the provision to remove the right to appeal deportation. And I know that you're a lawyer, so you obviously know the judicial system inside and out. And I just want you to comment on the fact that people who are convicted or charged with a crime actually have the right to go through the judicial system and have the right to appeals.
Yeah.
And
There
so
is, and in
forth.
fact, I think that there still is a ministerial ability to be able to address in certain circumstances those cases that should be reviewed. I mean, there are limits as a result of the Section 42.1 as is proposed right now. But there are still opportunities for the minister or those designated by the minister to ensure that in instances where it would be a grave injury to send someone out of the country, they could do that. So there are safety valves there for some of the categories. And you're correct, Ms. James. I think that we have a judicial system that is fair, that is exceptional when we look around the world, how fortunate we are. And I would say that it gets to a point where once you've exhausted those appeal processes in the context of criminal trials, that should suffice.
Now, we've talked about the impact it has on victims of crime, but is there a cost associated with that?
I made reference to the frustrations, and again, purely observational, but through the years, through the work that I've done, and looking at the way in which we have only so much ability to be able to address the backlog of cases that exist, whether it's in the Immigration Appeal Division or whether it's in our courts and ultimately the Federal Court of Canada. I mean, there's only so much that one can do to end up with a system that ensures that justice is addressed within a time frame that is acceptable.
Thank you, Mr. Shore. Ms. Sims.
Thank you.
Thank you very much. Thanks to all three of you for coming out and giving up your time to participate in critical debate, and I certainly appreciate your contributions. And having taught for years and years and dealt with students from diverse backgrounds, and also over the last number of years looking at research, Francisco, I certainly agree with you with the very factual information you put in front of us about certain students from diverse communities, from lower socioeconomic, representing a higher proportion when you look at who sits in our penitentiaries. I mean, that's a known figure. Nobody, that's just a fact. And that is not making excuses, but what it does do to us as a government is to challenge us to look at some of the circumstances and conditions that causes that, and gives us pause to reflect. And, from the work that OCASI does, and vast majority of your work with newcomers, and I think we're in agreement that law-abiding people, that most new Canadians, people who come to Canada, are law-abiding people who simply want to come to this country to make a better life for themselves and their children. They've all come here for different reasons and different routes, but eventually they want a better life. And as Jacques, you said, we are a country built by immigration, and we're and we're proud of that. And while on this side of the table we support the efforts to make sure violent, serious non-citizen criminals are removed from Canada quickly, we need to accept that this is a tiny minority. In fact, there is no evidence to suggest that permanent residents are any more prone to commit crime than citizens. So we really wish that this government would spend more effort making sure the vast majority of law-abiding newcomers are treated fairly and can be reunited with their loved ones and provide the support system they need. Sadly, we have a minister and a committee that seem keen on spending most of its time talking about immigrants as bogus.
Stop the clock for a minute. Ms. Sims, it's your dime, and you can talk about anything you like as long as it's on topic. But
this is on topic.
It is on. You know what? It is. Those sorts of comments could be left for debate when we debate the clauses. We're not in clause by clause. We're asking questions of witnesses, and you're making statements, which you're free to do. But I'm telling you. These guys over here are being held back. They're going to go at you, and I will not stop them if you continue to attack the minister.
I will go on to say that while I have sat at this committee, I have heard from committee members across the way talking about immigrants as bogus, queue jumpers, fraudsters, and these are quotes, and terrorists. Let me tell you...
Point of order, stop the clock. Mr. Menegakis.
In line with the intervention that you made, Mr. Chair, no one has ever referred to immigrants as bogus. That is a false statement. It's inflammatory, and Ms. Sims is going down the wrong path here.
When you talk about asylum seekers, they are immigrants as well. They come into this country. And I'm taking quotes from previous committee words that are being used.
Out of context. But what you're doing is out of context.
Okay.
And then we all
I was quiet while Ms. James did her thing, and I would really appreciate the same thing. Yeah. But here we are. As you probably know...
Carry on. Start the clock. Ms. James has a point of order, yes.
Thank you. I take a little bit of offense referring to me as doing my thing over here. I'm actually a member of Parliament in a committee trying to go through this particular bill with witnesses. So I would prefer that you actually don't speak to me in that context. Thank you.
That's true.
Thank you.
have to be respectful. We're all, as I've said many times, we're all honorable ladies and gentlemen, and I hope that we will act accordingly.
Well, Honourable ladies and gentlemen of the committee, as you all know, one of our biggest concerns with this legislation is the bill, that this bill will concentrate even more power in the hands of the minister, and that is actually what is in the bill. So my first question to you, Francisco or Amy, is, can you talk to us about how these new powers will affect the people you work with on a daily basis?
We are here to talk about the specific situation of no access to appeals.
Yes.
By a person that make a mistake. And we are talking about youth, you know, and you can make an exception of youth, and you can call a number of or years of age or whatever, but the person has to have an access. We are not asking for a pardon to the people that make a mistake. What we are asking is for the chance to explain the situations, because that situations, if the person is sent back, could be horrendous, and the future of that young person could be destroyed totally by a mistake. We understand that it's a mistake. We are not asking for that you forgot the mistake. We are asking that the person may have chances to justify and explain the circumstances about what happened.
Thank you very much for providing that classification, and I don't think any of us are saying that sometimes somebody can commit a crime that is so heinous that even with a 6-month sentence, you want them deported, right? There are such crimes out there. But what we're really talking about here is not the act of deportation itself. What we're talking about here is the right to appeal,
exactly,
which in our system we consider part of our due process, that because we pride ourselves on being a country that is governed by a rule of law. When you looked at this legislation, did you have any chance to take a look at amendments that could be made to this legislation that could help to protect due process and limit the increasingly arbitrary power of the minister?
We are focusing in the amendment of the Section 24, and we are asking for to remove it in order that the person have access to an appeal before the Immigration and Refugee Board. And the second thing that we are asking is if the bill itself can have a campaign to explain the circumstances and the consequences of the implementation of the bill for the racialized communities, and specifically youth people, because we don't have that situation in the curriculums, in the schools, in high school and wherever. So we are asking you also to include something that is going to explain the implications of this bill to the young people of Canada and permanent residents and otherwise.
Okay. So my understanding from what you've just said is you would ask that the appeal process be reinstated.
Exactly.
So that even like right now we have appeal process for sentencing above 2 years. Now that we've lowered the bar or raised the bar, whichever way you want to look at it, to 6 months, that appeal should be there for everyone, and that once they have if this legislation should pass without any appeals, that there be education done to raise people's awareness around these issues.
Even if the bill is passed with the amendment of the appeal, I think the campaign and the changes of the curriculum has to be suggested in order that the young and children knows about the implications of this bill.
Thank you very much. As you know, filing an application to immigrate to Canada can be a lengthy and challenging process. I actually took a look at the forms when I was in my riding last week, as somebody came in to ask for help because they were struggling with it. And when you look at that, there is the potential of honest mistakes on an application. Do you think the 5-year inadmissibility is an overly punitive measure for what could be an honest mistake?
It is, particularly because that affects many persons that are obligated to make that mistake. Let me put an example. Some women that are in a very impulsive or violent relationship where the husband fill all the application and force them to leave children behind, for instance, that are not named because the husband doesn't want to name it, and they come here, that could be a mistake, that could be serious implications, and the women in that particular time didn't have anything to desire to say at that particular moment. And that case has to be explored in a particular way under humanitarian and circumstances, for instance.
Mr. Lamoureux.
Chair, I did want to approach it with maybe from a different perspective. First, to recognize that this bill actually affects 1.5 million plus people that call Canada their home, permanent residents, which means that we should all be very much concerned in terms of the content of the legislation itself. The government, in introducing it, listed its 5 reasons, and that, of course, is those extreme cases. I would like to give you a case which has been talked about, I've had the opportunity to raise in the past. Imagine, if you will, you're a 19-year-old graduate, maybe living in Windsor, Vancouver, Montreal, and you make the decision that you're going to go stateside to celebrate your grad. And they have an age of 21 in order to drink, so you use some false identification in order to be able to get your bottle of wine or your alcohol so you can consume it. Well, in that sort of a situation, you will, in fact, be deported, and you will not have the right to appeal. And one of the presenters actually put it quite well, provided a document, and this is the reason why ultimately you would lose the right to appeal. Using a false or fraudulent document is an offense under Section 368 of the Criminal Code, carrying a maximum potential in a penalty of 10 years to 20-year-old permanent resident who is convicted of using a false or fake identification to get in the bar while visiting in the U.S. is inadmissible under IRPA for foreign conviction. It doesn't matter that the U.S. court punishment might only be a $200 fine. The point is that this legislation is so encompassing of that 1.5 million permanent residents that live in Canada that a 20 or a 19-year-old youth that happens to use poor judgment by using false identification is ultimately not going to have the right to appeal and is going to be deported. The rest of the family stays here, but is going to be deported. I'm wondering if you feel, when you think of that sort of an example, that maybe the government has gone a little overboard and we need to improve the legislation before it leaves this committee, and that would be a big for sure. Would you agree? Mr. Shore, Francisco, or whoever would like to respond to it.
That's exactly the examples that we're thinking. You can go on and on and on in the examples where we consider, we understand that it's a fault, that is prescribed in the law, but on the other hand, we understand that was a mistake. And that person is going to learn very quickly that this is something that is not going to do again. And we try to explain it to everybody, but that's when peer pressure comes across. Why? Because many other Canadian-born children, they have that situation as well, and they will do the same mistake. And in a group of people, one will be targeted and deported, and the other one will stay without a problem, making the same mistake, both of them. And that's why youth need to have a way to explain the circumstances and give them a second chance. What we are asking is to give the young person a second chance, to consider that it's a mistake, and to consider the human being that you have in front of you.
Yes. Secondly, Mr. Shore, if you don't mind, think in terms of misrepresentation. Now we're increasing it from 2 years to 5 years in terms of being able to get a pardon. I ask you in particular, Mr. Shore, have you heard of unintentional misrepresentation that has actually occurred? And if so, do you think it would be appropriate to be extending a pardon required from 2 years to 5 years? And you might want to comment on the earlier question.
I haven't actually heard of that, and I don't know how that would necessarily be addressed. But I do think that we do have safety valves in our judiciary, in our legal system, that would allow an individual to seek judicial review in circumstances where we see grave circumstances developing. And I think that as well, in this particular instance that you have shared, I believe that there is an opportunity to seek under humanitarian compassionate grounds, the ability to seek the minister's leave to actually exclude that from happening with respect to a situation as you described. But I would also want us to go back, though, to what I had shared earlier, and I think my colleagues did as well, the importance of education, the importance of ensuring that we do create good citizenship, that among the, and again, the vast, vast majority, 95, 99%, I'm a first-generation Canadian here. When I think of the immigrants in that 1.5 million, I think, which you referred to, there needs to be a better appreciation of good citizenship in the context of not allowing young individuals to get into these sets of circumstances. But I do want to repeat that even in the context of the court process, I do not think that our system would allow someone to be deported or to be sent back to a country that he or she does not know in a situation like that where it's as a result of a misrepresentation in that instance. I do believe we do have those
Mr. Lamoureux, we're over your time. Mr. Weston.
Thanks, Chair, and thank you. This has been a really engaging discussion. As an Osgoode Hall student who worked at the Parkdale Legal Aid Clinic, I served many of the people that I think, at least the genre of people that you're serving today, and I understand where you're coming from. I really appreciate what both of you are saying about this public education. The ounce of prevention is worth a pound of cure. And given that we're dealing with the minister who was so proactive in promoting his citizenship guide, I think he will be very interested in the suggestion that both of you make. I want to point out some of the things, especially Francisco and Amy, in response to your presentation. And then I need to get to a question for you, Jacques. Our government has tripled settlement funding, so a lot of the people that we're talking about here that you feel are more at risk have been helped to integrate in Canadian society, for instance, with free language classes that they're getting. So I think we should take that into account. And also, we will abide by the Geneva Convention. No person will be left stateless. In addition, persons will get access to pre-removal risk assessment to ensure we're not sending people back to torture. That's our goal, and our government will be committed to implementing that goal. Certainly, anyone who looks like he or she is going to be harmed will be allowed to stay, at least temporarily, while that risk is assessed. I was very interested, Jacques, in your suggestions about clarifying the criteria that would guide the minister. And you mentioned there would be 3 benefits from doing that. I'm wondering if you could be a little more specific on that. And then secondly, this concern that my colleague Mr. Lamoureux brought up, I share it, this idea that people who make misrepresentations, is there going to be a disproportionate kind of a response to that? Do you see any remedy that might come in the clarifying of the discretion that you've referred to?
With regard, thank you very much, Mr. Weston. With regard to the issue of the guidelines, again, I believe that there is an added benefit if the minister would decide, along with parliamentarians, that the inclusion of the specific guidelines described as best as possible in the legislation would be an advantage. One, because I think the way in which we look at the way it's written right now, public policy can be extremely broad, but it could also be regarded as vague in the way in which it's implemented. I could see someone going to court and basically saying it's too vague. And it could be, there's a concept also of void for vagueness where one may try to apply that because of the vague element of it. There's also the added benefit that with that clarity, you're not going to ultimately have, and while I have enormous respect for the judiciary and our courts, I could see a judge not really understanding what it is and limiting what it is that the government may want to do in a particular instance. And usually these kinds of cases happen very quickly. Speaker coming to a university or an individual coming into a community center, all within 2 days of trying to decide whether or not someone will get the permit to be able to come, as we've seen in some of those circumstances with individuals that clearly did not respect our values. So I would probably say with the inclusion of that, there is a guarantee that we would be able to at least know with clarity what those issues are, and I think the government's intentions, and for Canadians, there would be a benefit for that.
Well, I've noted that, and I just want to reiterate something we've all heard But I think everyone in this room takes pride in Canada's record in settling refugees. Per capita, we settle more than any other country in the world, and we continue to embark on that generous refugee resettlement program. So my hope, and I think my colleagues' hope, is that by ensuring that criminals are deported more quickly and not unnecessarily, unfairly clogging up our legal system, we will continue to have the public support we need for a very generous refugee program, so that the people I met at Parkdale and the people you're serving will continue to come to Canada for a safe haven. Thank you, Mr. Chair.
Okay. You still got a.
Share with.
I can't believe you guys
Mr.
are going
West,
to quit.
May I just add,
Mr. Shore.
Thank you very much, Mr. Chair. The point also with respect to making sure that our classrooms have the benefit of understanding good citizenship. You know, I have the good fortune of being chair of Carleton University for a number of years. I look at how we don't use our universities nearly enough to address these kinds of issues. How wonderful it would be if the minister could call in the presidents of the universities to sit down. How do we address this? How do we get every principal in the nation focused on this? How can we get our provinces to understand good citizenship, and that the risks that these children, and they are risks, because how unusual it is that a child who is an immigrant, who's not a Canadian citizen, and a child who just is a citizen, in the same exact set of circumstances, one could be deported and one cannot. But that is the way the system works.
Well, even our elementary schools, if
Precisely, and that's why the
on
classrooms to be able
jurisdiction,
to include that.
Well, I'm so glad that you added that.
Thank you.
Chair, do we have more time?
2 minutes. Oh, a minute and a half.
All right. I'm going to share my time with Mr. Dykstra.
Thanks. Mr. Shore, I wanted to get from you, you've touched on this a couple of times, including in your opening remarks, and that is the issue, and we've had a number of witnesses talk about the serious criminality is currently defined in IRPA, and how this changes both under Section 24, as you noted, and also within the context of the lowering from 2 years to 6 months, and what kind of implication that has had. We have what I find to be extreme examples of an underage student who goes to the United States and is found out to be underage and therefore convicted, and somehow that is going to mean that individual, if they're a permanent resident, is going to be deported back to their country of origin, which, of course, I'd like to get your thoughts on, and from a legal perspective, because when you look at how the bill is laid out in terms of both 36.1 all the way from A to C, and then the whole aspect of where and what this means. For example, Section B, having been convicted outside of Canada of an offence that, if committed in Canada, would constitute an indictable offence under an Act of Parliament, or of two offences not arising out of a single occurrence, if committed in Canada, would constitute offences under an Act of Parliament. We're having some struggles here, and I'd really like to get your opinion on this.
I'm afraid we're out of time.
That's fine. I've got the next 5 minutes, so I'll just let you answer.
No, actually, Madame Gouet does.
No, the following 5 after her.
Thank you, Mr. Chair. First of all, I think it's important to remember that we all agree here, the official opposition included, that it is important to be able to deal more rapidly with the cases of foreign nationals who commit serious crimes in Canada. However, there are really issues and concerns that have been raised by C-43 that mainly affect what you've talked about, Francisco, and Mr. Shore as well, regarding teenagers, youth, who came when they were young to Canada. In addition, you talked about the rehabilitation potential, which, in my opinion, is very appropriate here when it comes to young people. We know that in Australia, until 1999, a law protected permanent residents who had been there for at least 10 years against removal. It guaranteed that people who arrived when they were very young and who grew up and started a family in their host country had protection against removal to a country that they never knew. Should we not integrate a provision into this bill that recognizes the union a person has with Canada, especially if the person arrived when they were very young? What do you think?
abilities that you can have, particularly for young people. We have many cases in our agencies where the young start having problems during the adolescence, and they have depression, they have mental issues, they have many things. They run out of the house, they become a problem, and then realize that they are no citizen of Canada, maybe 10 or 15 years after the fact, when they already have committed mistakes sometimes. And some of them have serious mental issues that we have to deal with this situation. If you put a period of time to avoid for this person to be sent to areas or countries where they haven't even been before, or they left very young, that will be a possibility that is going to protect people. And that could be dealt also in the appeal situation, because if they have the right to appeal, they can go with the medical records, with many things to explain why the situation happened. And sometimes it's no fault of the parents. It's fault of the situation that young people make mistakes, and we want to protect the person. We know that it's a mistake, but the circumstances has to be known first, and one is a period of time. 5 years, 10 years is up to you, but that's a good way to deal with the young situation, or the situation for young people.
Monsieur Shaw,
Mr. Shore, thank you very much.
Is that the way the words are now included in the proposed legislation? Bill C-43 does, under Section 25.1 and Section 25.11, does provide for a minister to be able to make the decision of not having that person leave the country. So I do think that safety valve is there, except for very exceptional circumstances, if there is a certain if it's under espionage, or whether it's under certain criminal behavior that is criminal organizational behavior, and also with regard to crimes against humanity. But I do specifically believe that without the right to the Immigration Appeal Division, there still is that safety valve. Otherwise, I'm not quite sure what these changes are, what the main change in this legislation would be. We're basically back to the current system. And that's the frustration that I spoke of earlier, where unfortunately too many people have been taking advantage of it.
Okay. Monsieur Francisco, vous...
Francisco, you recommended that we maintain the right to appeal, and many of our witnesses spoke to us about the very large net that Bill C-43 is, because it will also target real criminals, in quotations, and also young people who might have arrived when they were very young to Canada, who might also be caught in this net. So many people fear that Bill C-43 is a disproportionate measure. In your opinion, is the right to appeal a fundamental component of due process? What do you think?
Of appeal is a fundamental component in every single area of law that I want to have in the country that I am living, that I am a citizen of. Not appeal, no access to appeal, is an anti-democratic measure.
Thank you. Mr. Dijkstra, you have until the end of the half hour.
Great. Mr. Shore, I asked my first question already. You stole my thunder a little bit on the second, how you just responded to Ms. Gergouet, but if you could respond directly to the issue around criminality and the extent of what a minor crime would be. Because what's happening is there's an overlap here of what could potentially be seen as a minor crime and what would potentially be seen as a serious crime, and a big difference between how it's being skewed in terms of understanding what is that, where does that serious crime threshold begin?
Again, I do believe that there are sufficient safety valves in the system as it is defined right now in the legislation, with the exception that in certain circumstances, for those which have been identified as extremely serious, and those are the three I mentioned earlier with regard to national security issues, those with regard to criminality in the context of criminal organizations, and also with regard to human and compassionate grounds. It is unimaginable And again, I realize we're looking at extremes, but recognizing the system as I understand it to be after 32 years of practicing law in Canada, and appreciating the work that I've done, I guess, through the courts and public policy work, that someone who has committed that kind of an act would be thrown out of the country without the ability of, and I appreciate what my colleague, my new friend here on the panel actually says, that there would not be a right of appeal. It's undemocratic. I don't think that in our country we would throw that person out of the country, because part of it also is there is an element of what officials are going to run after that person to do that. I mean, you look at, there are a number of instances here where the decision is made, do we throw this person out or not? I mean, who's going to act upon that? You know, and so it comes down to, when we look at the unreasonableness of a situation like that, I would think that a minister or his delegate would appreciate that an individual like that should not be thrown out of the country. But then I keep on going back to my underlying theme. We have to make sure that individuals appreciate their obligations, their rights, and their responsibilities.
No, I think that's fair. I think that's been, regardless of those that are presenting would agree with you on, certainly in that matter.
And I don't think it's a blind faith. I think it's a faith based on, reasonable judgment.
A blind faith isn't what is suggested in Section 42.1,
Exactly.
Which gives the
I
minister
agree.
a new authority to prevent someone from being thrown out of the country.
But I'm not.
And I appreciate you bringing it up. It's where I was leading with my next question, because I continue to not understand why folks, and maybe Mr. Rico Martinez, you can enlighten me in this. Why do you not mention Section 42.1 in terms of saying that it does augment and gives a threshold for the Minister of Public Safety to prevent someone from being thrown out of the country if, in fact, they've done something of a minor offense that has been interpreted as a serious one? The other point on this, and I guess this is where rule of law and how do we pass legislation that says a youth should be given a second chance? Like, I don't know how you define that in legislation. If someone commits a crime and they're convicted of that crime, regardless of their age, I know you're taking into capacity this whole issue of mental health and their issues of how they are doing psychologically. Those are issues faced by the courts every day. Mr. Shore was involved in a case that took years to determine. I know for a fact that the issue of mental health and the capacity from a psychological perspective to stand trial are one of the issues that is faced on a daily basis in the court of law. So if an individual, regardless of age, well, then why shouldn't a senior citizen of the age of 83 who commits a crime not be waived in the legislation? We have to define within the legislation how we're going to and how we're not going to treat people in the court of law. So if you're going to speak that we need to help youth, and I agree with all of those things, but if you're going to define it in legislation, explain to me how.
For me, second chance means an appeal. And I think the minister...
You don't think 42.1 is an appeal? Okay, I understand.
And the minister, I agree, then has to have the last word, if you want to put it like that. But as a quasi-judicial system that you have in place in Canada, will be a good idea that the person has a chance to explain the situation in an appeal. And let me just finish with this. We include the appeal division in the IRPA because we didn't have one, and a person has to have the second chance to go there. And now here we are canceling. And in my opinion, that's not possible to use it in a double standard. You have to give the right to appeal to people. That's part of the democracy.
Mr. Shore, are we giving the right to appeal within this new legislation?
I think it's a different venue to address issues. I think we do see that here. My sense is that too often, sadly too often, we see people that are seeking that right to appeal only for the purpose of delay. And again, creating the frustration, the cost of the system, and I think what we need to do is focus on other ways in which to address those issues, and I think this is a reasonable way of going forward as the legislation is identified right now.
Okay, thank you.
Okay, thank you very much, Mr. Shore, Mr. Rico Martinez, Mrs. Caspilli. Thank you very much for coming and giving us your views.
Thanks someone that is with me here today, Julia Warrenberg, who was very helpful also in the research that she
Julia Warrenberg. Stand up and take a bow. Good to see you.
Thank you very much, Honorable
Thank you very much.
Appreciate
We
it.
will suspend. Okay, we'll start the second hour. We have three witnesses before us. Rear Admiral Donald Lauren, good afternoon to you, sir. Walter Purcell, and George Plattis. Good afternoon to you. Mr. Purcell, we'll start with you. The three of you each have 8 minutes, up to 8 minutes.
In fact, with your permission, Mr. Chair, my colleague is going to start. We've prepared this in a slightly different order.
Oh, I never wanted.
I don't know, Chair.
Let's think about this. Okay, Mr. Plattis, you can go first.
That would be me. Chair and members of the committee, once again, thank you for your invitation. With me today are my colleagues, Rear Admiral Don Lauren of the U.S. Navy and Professor Walter Purcell of York University. We're all part of the Center of Excellence in Security, Resilience, and Intelligence at the Schulich School of Business, but today our comments are our own and do not reflect any organizations we may be associated with. As a child of immigrants, I have been fortunate to win the lottery and to be born in this great nation, a country that has provided countless opportunities to people like my parents. They came here in search of a better life with a view to adopting Canadian values and contributing to Canadian society. I believe that the majority of our immigrants are like my own parents, honest, law-abiding, and love Canada. With that in mind, I would like to draw the committee's attention to this stark reality. We do live in a world that has considerable dangers. And we must accept that there are those who seek to take advantage of our welcoming system, undermine our interests both here and abroad, and even maliciously hurt us. As previously noted, technology is an enabler, creating an asymmetric capability for the individual. Flight patterns have changed, communication systems have kept us connected, and our dependence on cyber systems should really force us to rethink how we educate our citizens, both young and old, as we further expand the use of them. Within that context, I would respectfully say that much of the current discussion surrounding this bill views the world from a very reactive perspective. I believe this to be a mistake. As a consequence, the discussion is focused on law enforcement, judicial process, and review boards. Respectfully, I ask, why is there not more discussion on a proactive approach? From local community engagement to foreign intelligence collection, information is ultimately what gives our visa-issuing officers the ability to make informed decisions about individuals entering Canada. I believe proactivity, which is more related to national security, would result in fewer cases of deportation, lower rates of incarceration, and a reduction in fraud, which in turn should make resources available to new immigrants and refugees. With respect, much of the analysis is focused on rare cases. On one end, we have cases that are tragic of police officers that are killed. As somebody who works closely with law enforcement and first responders, many of which I call friends, incidents like this trouble me. But these cases demonstrate that there's a gap in the legislation and shouldn't be used for sole justification for the amendments. There have been also cases about persons with potential mental illness. Respectfully, I don't think we should be tossing away amendments due to rare cases or issues that may take years to materialize, especially when they don't address the root cause. In this specific case, I would say the solution is better training of visa-issuing officers that can potentially identify cases of mental illness and immediately refer the case to a counselor. Another case has been the threshold for right of appeal, and the example of 6 marijuana plants has been used. I asked the committee to consider this. One plant, on average, can produce about 4 ounces of marijuana. At a street value of $350 per ounce, 6 plants are worth about $8,400 and can produce 24 ounces. Where the average ounce can produce 30 joints, 24 ounces produces 720. Respectfully, I think this is trafficking, and Canada does not need any more drug traffickers. I also have concern about...
Mr. Plattis, could I interrupt you just for a second?
Sure.
This is being translated into French.
Okay.
So you'll have to slow down.
Will do. My apologies for that. Sorry, translator.
Thank you.
All right. I also have a concern that trials and lengthy sentences are avoided by pleading guilty to a charge of 2 years minus a day. This allows a foreign national to seek review of their deportation order. The cases that have been presented, there are multiple assaults, failure to comply with the courts, fraud, drug trafficking, and due to the sentence length, deportation had been put off, sometimes by an average of 6 years. I think a gap clearly exists here where the criminal justice system and the immigration review system do not align, and this results in a situation that can be exploited. There's also concern over the public policy consideration. With respect, I feel these fears are overstated, particularly when they are looked at contextually. I see the provision as a final stop to ensuring Canada's safety and security, not the front-end consideration to admissibility. And while I don't mean to equate the two, I think a comparison here may be beneficial. The notwithstanding clause is essentially a public policy consideration designed to override Sections 2 and 7 through 15 of the Charter. It is only used in exceptional circumstances to make important policy decisions that are isolated from judicial review. Invoking the notwithstanding clause, though, has ramifications for the government of the day. The political cost could be significant, and I believe this is why we do not see it invoked frequently. Respectfully, in the larger context, this is how I see the public policy consideration being used. Any misuse of this provision, particularly in today's real-time media and information context, I think would be proved politically damaging. If used in exceptional circumstances to address a gap, such as barring a foreign national who spews hate speech, I think this is in the Canadian interest. The Criminal Code of Canada in Sections 318, 319, and 320 forbids hate propaganda with clear definitions. The Human Rights Act under Sections 3 and 13 also has definitions. Hate speech may not be a crime in another country, but it is in ours. Therefore, I see this provision as closing a gap, and it's not unreasonable, especially when the government of the day has to consider the enormous political cost if misused. Lastly, has the committee discussed the public policy consideration to be used as admissibility for extraordinary cases? The example of the foreign national who came at a very young age and only knows Canada as their home has been cited many times. Could this provision be used to keep somebody in Canada for humanitarian compassionate grounds for these rare cases? I'm not sure this was the intent of the consideration, but if used this way, it would certainly address some of the concerns that have come before this committee. Within the larger context of national security, which also includes information gathering, coupled with law enforcement, and along the full continuum of the immigration process, taking into account potential political considerations, I feel that the bill is balanced and proactively addresses many of the issues Canada faces, while also serving the Canadian interest in the long term. It is at this point where I would like to ask my colleague, Professor Purcell, to speak slower than I did and to highlight some more specific cases. Thank you.
I, too, am a child of immigrants. I therefore echo my colleagues' comments, particularly that the majority of immigrants in this country are law-abiding, honest, striving to establish a better life, and integrating Canadian values into their own. On a go-forward basis, I strongly believe that Canada's future prosperity is directly linked to a sound immigration policy. That policy should attract the best minds and the best talents in the world. Welcome those who wish to adopt a Canadian set of values, but also incorporate the strong values and belief that we cherish, which include assisting those based on compassion and humanitarian grounds, no matter where in the world they come from. Furthermore, our society cherishes the security and stability of the rule of law. As Canadians, we have a right to be before the courts to defend ourselves. So should foreign nationals here temporarily or on a permanent basis. However, as a believer in planning for even exceptional cases, we should not lose sight of the bigger picture. If the committee accepts realities, including the dangers of the world in 2012, as I and my colleagues have illustrated here and in the past, the amendments in Bill C-43 proposed should be characterized as the end point of the immigration process, not the starting point. There have been recent examples of potential abuse of our welcoming system. Most recently, the Project Sarah report, of which I'm sure you are familiar, conducted by CBSA, has warned of significant level of welfare fraud and other crimes. Violations have stemmed from altered or falsified names, financial thefts, manipulation to receive benefits, even after deportation, and even the prospect and possibility that there has been human trafficking. What the Project Sarah report demonstrated is that the abuse of our system is not only letting some of the wrong people into our country, but it's also drawing away valuable resources away from critical areas that should be addressed in the interest of those who should be admitted to our country. These include services to help our newest residents find jobs and do things like learn our official languages. Additionally, the Project SARA findings also show us that there is a level of sophistication being used against, thus exploiting our existing safety net. For example, travel patterns are no longer point A to point B. Rather, there are intermediary countries being used, such as traveling from Europe to Mexico, sneaking into the United States, and subsequently entering Canada through border towns in various communities with an aim to making claims within Canada. There have been calls for increased RCMP patrols along the border, including better staffing and tougher detention measures. I would suggest that these are warranted, for if we are to do a better job in protecting our borders at all points of entry, land, sea, and air, there would be lesser need to focus on detention measures. With respect, though, simply having more RCMP patrols along our borders does not address the heart of the issue. This issue is more complex as we look to appropriate decreasing resources. For example, to have increased patrols, the RCMP needs to have a level of insight as to where to patrol, what to look for, and who to be on the lookout for. Ladies and gentlemen, efficiency in this area is a function of the degree to which we have effective information or intelligence. Furthermore, increased patrols along the border only addresses specific cases, not the whole issue, especially when we have certain groups making disproportionate amounts of refugee claims at some of our country's largest airports or ports. This is why I feel it is appropriate to request, if CBSA official deems it so, a further review in certain cases by CSIS officials. With respect, if people want to enter our country, and it is reasonable for us to want to know who they are. To give you a micro perspective, there's a simple question here that animates this perspective. Would you give to a stranger the keys to your house? Ladies and gentlemen, our house is Canada. We have a right to know who is coming into our house. We have a right to protect ourselves from the potential dangers of a person unknown to us in terms of their background or their intentions. I have stated that the amendments proposed by C-43 should be looking along the continuum of the immigration process and not judged by its singular amendments. Increased RCMP patrols and increased staff at borders are of limited value if we do not have the information and intelligence backbone to support them. They are of even lesser value if our agency officials do not have the necessary training to spot potential issues. The ideal situation is to make sure that potential abusers never reach Canada. Having said that, I'm fully cognizant of the fact that our defenses will never exclude 100% of those who would seek to do us harm. This is why I see as C-43 amendments as final safeguards in a larger apparatus, which includes but is not limited to national security, law enforcement, support and assistance to the immigrant or refugee claims, and integration into Canadian society. If a foreign national is deemed to be a threat to national security, they should not be admitted to Canada. If an offense is made by a foreign national, they deserve their day in court, but we should not hold them to a different standard. We should hold them to a single Canadian standard. For those not as fortunate, it is a privilege. Wrong. For those born in this country, it is rare privilege. For those not as fortunate, this is not a right. It remains a privilege. It is therefore reasonable to expect people who wish to come to Canada to have a clean record, just as it is reasonable for us to expect that they obey the laws and the expectations of this society. Unfortunately, not only is our current system exploitable, but it is dated as compared to our international partners and allies. For example, places like Japan, the United States, and the European Union, along with a string of other nations, all require something as simple as photos on visas. Canada does not. Furthermore, we lack back-end safeguards that support our frontline agents. While we are seeking to make a uniquely Canadian policy, we should consider the benefits that other countries employed, particularly when a border officer deems a foreign national inadmissible. Within the Canadian context, according to the Treasury Board, rarely is an initial assessment overturned. In the year 2000, or the period 2009-2010, only 3%, approximately 100 cases were overturned, yet 18% of those who were not overturned, approximately 600 people, failed to appear for their hearings that had been granted to them as a matter of their right. I have only brought before this committee a few issues, but as my colleague noted, I agree that C-43 should be looked at in a more holistic manner along the entire continuum of the immigration and refugee process. Within that context, the bill addresses many of the issues Canada faces. Additionally, as we have noted previously, the backbone of any apparatus used is sound information. Without this, we cannot make informed decisions. At this point, I would like to ask a great friend of Canada, retired Admiral Donald Loren of the United States Navy, to give us his perspective on how his country has had to face similar issues. Thank you.
Good afternoon, Mr. Chairman and members of the committee. As a great friend of Canada, it is a pleasure to be here again. And as before, it is at my colleagues' request that I appear before you. All comments made by me today are my own and not reflective of any of the organizations that I may be affiliated with. I recognize that today's focus is on Bill C-43, but as I have noted in my previous testimonies before this committee, pardon me, I'm not here to address the law in specific, as it would be inappropriate for me as an American to do so. What I wish to offer today to all of you is a perspective on how my own country has dealt with similar issues, including the challenges and lessons learned, and what factors we considered in our own decision-making process. As Deputy Director for Operations Support at the U.S. National Counterterrorism Center, and as Deputy Assistant Secretary of Defense for Homeland Security Integration, I was able to see firsthand how immigration patterns in my own country have changed over the years. While these patterns changes do not mirror Canada's, I am certain that there are many commonalities between both nations. Like many of you here in Canada, my own ancestry in the United States started from the Old World. In my own case, my great-grandparents and grandparents immigrated to the United States from Europe. But is the concept of immigration the same today as it was when my ancestors crossed the ocean? The long journey of past immigrants had a profound and irreversible effect on their lives, moving to the New World, to places like the United States, Canada, and Australia. It was driven by establishing permanent integration into a Western society founded on the principles of fundamental freedoms, the right to own property, and the ability to live a prosperous life. Also, the immigrants' intent rarely included plans to travel back and forth from country of origin to country of immigration. It was picking up and leaving for good. Immigrants left their home knowing they may never see their family again. Ellis Island, Halifax, and Fremantle, immigrants strove hard to integrate by learning the local language, working in some of the harshest conditions, and sadly, even suffered the treatment of being labeled a second-class citizen. Their tenacity and perseverance in these hard times has been woven into our respective histories and societies, highlighted by meaningful contributions we should all be proud of. But as my colleagues noted, we need to consider today's realities, which include technology as an enabler and ever-changing intent. Airplanes have reshaped immigration patterns and travel behavior. Travel that once took 2 weeks and cost a small fortune now takes hours and is affordable for most persons. Communication was limited to the monthly letter and the odd, short, and expensive phone call. Today we place unlimited international phone calls for a flat fee. We have video chats and even paltry amounts of cash that were tucked away in the pages of a book or under the mattress sent by mail have been replaced by instantaneous wire transfer and electronic banking. Integration is different as well. Many pressures of blending into a community are gone, as we have local ethnic towns, such as in the United States, Little Italy, Greek Town, Chinatown. When these towns have reached critical mass, virtually every service and amenity is offered in the language and the tradition of the home country. Satellite TV and the Internet allow the immigrant to follow events back home, potentially limiting their desire to learn English or French. Instead of reading the local Canadian or American newspapers, they follow news on their homeland, of their homeland, in their native language. Immigration used to be about work and opportunity. Now it includes family reunification as well. a once costly process for a sponsor, which often was the original immigrant themselves. And today there is a societal safety net designed to protect the newest members of our society, something that did not exist for the first and second wave of immigrants to my own country. The above is not designed to cast a wide stroke on the immigrants' ability to integrate. Rather, it is designed to demonstrate that the context has changed considerably. Like my colleagues, I also believe that the majority of immigrants are honest, law-abiding, decent people with strong values. Statistically, the percentage of those seeking to take advantage or do harm to either of our countries is small. But as my colleagues noted, it is the asymmetry that has expanded the threat spectrum and forces us to reconsider intents. I can say with strong certainty, given my experiences, that those who seek to take advantage of us and strive to hurt us use unbelievable levels of sophistication, some which are not necessarily evident at first glance. Manuals on how to abuse our judicial system can be found on the Internet. Shady agents within our own countries consult on how to beat the system. Preferred travel routes and entry points are identified and shared. And what is even more worrisome in the 21st century is the coalescing of transnational organized crime and terrorism. What may seem like petty crime may in fact be part of a more elaborate scheme to circumvent the safeguards of our respective immigration systems. Lines have become blurred, requiring us to do more. From a national security perspective, this can include the expansion of information gathering. As noted previously, HUMINT, Human Intelligence Gathering, is vital to the security of the nation, and as my colleague stated before, HUMINT should not be viewed as some shadowy intelligence operation, but rather it is something that can include immigrant community engagement by local elected officials and law enforcement officials, a tactic that, if instituted properly, can be very effective. From a law enforcement perspective, we want to ensure even foreign nationals get their day in court if they commit a crime, but we must have legislative and operational tools that remove them faster from our respective homes. I echo the comments of my colleagues. Once a person is within our borders, it becomes much more difficult to deport them. All Western democracies face this challenge, which is why I believe any legislative actions you decide should take account for the dynamics of our time. Investing in systems, processes, and most important, people that focus on proactivity and protecting our interests should be paramount. In 2012 and moving forward, it is not unreasonable to want to know more about somebody who is trying to enter our countries. By the same token, you want to ensure that privacy and fundamental freedoms are protected and people are treated with dignity and respect, fully understanding that there are legitimate humanitarian and compassionate causes that must be dealt with as they arise. A proactive strategy which prevents unfriendly foreign nationals from ever reaching our borders is a strategy that reduces the need for back-end safeguards and frees up resources for those who have legitimate need for them. Furthermore, measures that seek out malicious intent are not a great deal to ask of anyone wishing to pass your borders, particularly in today's context. I believe that Canada, much like the United States, will welcome those who seek to share our values and respect our laws. Therefore, it is not unreasonable to hold foreign nationals to the same standards we hold our own citizens. In closing, both the United States and Canada have talented professionals that can assist with these issues. We must reach out to them with a view of supporting the human and technical resources required. Insomuch, I feel it will ensure that the legitimate foreign national not only stays both in the United States and in Canada, but also makes meaningful contribution to both of our great societies. Thank you again for having me here with you again today.
Thank you, gentlemen. The members of the committee do have some questions, and we'll start with Mr. Opitz.
Mr. Chair, For you, to our witnesses. Thank you once again, witnesses, for being here. Admiral, welcome back to Canada. It's good to see you again, sir. I'd like to point out a couple of things before we start our discussion, where Canada really is. We still remain one of the top countries in the world who welcomes refugees. We welcome more refugees per capita than any G20 country. Canada welcomes approximately 1 in 10 of the world's resettled refugees, and that's more than per capita than almost any other country. And in fact, our government has agreed to increase the resettling of refugees, in this case by over 2,500 a year. And as for immigrants, we allowed over 280,000 new immigrants into the country last year, and the vast majority of them are good, decent, hardworking, contributing people, and those are the people we want in Canada, as Professor Purcell pointed out. We do need to attract the best, most industrious minds out there to help us build and achieve this country. And Admiral, one of the things that you ended up in is, ended your discussion on, is the knowledge that an individual has coming in this country about our laws. Is ignorance any excuse when you come to a new country about its laws? What's the responsibility of that individual?
Was that directed
to the Admiral?
Yeah, unless we're promoting you today, George. Thank you, sir. The same thing holds with traffic violation. Ignorance is no defense for the law. That doesn't mean we can't be compassionate and reasonable and use judgment when we determine intent, but ignorance is not a defense.
Now, Colonel Purcell, what's your view on education? Previous witness had suggested that the universities have a role to play in the education of citizenship and people who are PRs and perhaps not citizens at the time. What would your view be?
We have a unique issue here that one of the parliamentarians mentioned in the earlier testimony. We are the only country in the Western world that has no national Ministry of Education. Since this is a provincial responsibility, this is something that needs to be encouraged and certainly should be encouraged. And a view of Canada should be facilitated through our universities. But it is difficult to do that through the federal level except by way of asking or encouraging it. And certainly the federal level should both ask and encourage. That's an important function. But I agree with one of your colleagues, Mr. Opitz, that form of education should frankly be downloaded all the way from the university level down to the school level. So a kid knows, for a parent that doesn't speak the language, a kid knows that there might be concerns or there might be issues, so that family can be sensitized to any concerns or issues proactively as opposed to reactively when somebody knocks on the door and says, "What are you doing here?" I think these issues should be brought to the attention of the public. But again, I would submit that the universities and schools are not the only, nor perhaps are they even in the 21st century, the best form of education. I think it would be incumbent upon us in our national interest to bring that out to people using media. And certainly the various forms of media have a great deal more penetration, particularly among young people, than many university professors.
You'd also mentioned the cost to this country. Can you talk about the cost to this country, not only in CBSA and RCMP patrols, but the possible cost of criminality in this country and the cost of victims?
I want to address that to leverage off a point that Admiral Lauren has said. You know, there is a real lack of consciousness in Canada about this word called asymmetry. The 21st century has fundamentally changed the game. For the first time in human history, a single individual can make war on the entire planet. A single individual using a technology as common as his computer can cause devastating destruction in a country. Yesterday I did a simulation at York University, and we used exactly that scenario where a single individual unhappy with, for whatever reason in this country, perpetrated a cyber attack that impacted our critical infrastructure. The cost of that, again, was devastating, and the best professionals in the room had no idea how to cope with something as simple as that. We have things to fear that we did not need to fear a generation ago. We have an entire generation of people that can cause us injury unexpected in previous times. And that's why it is important for us to be vigilant. We are not concerned about the vast majority of immigrants that come to this country. What we are concerned about is the asymmetrical threat that can cause us undue harm. And that harm can be not disastrous, ladies and gentlemen. It can, in fact, be catastrophic.
Admiral, this morning this committee had a chat about ETA system, protocols to keep people out offshore, as you know, which would be modeled very similarly on the American system, which I think when implemented will help a great deal in that regard. But you also talked about the acquisition of intelligence and sharing that acquisition. Can you elaborate, sir, on how HUMINT and other intelligence capabilities would be shared amongst allies?
Obviously, remember, intent is a significant piece of the types of things we're discussing here today. And the way you determine intent is generally through intelligence, whether it be associations, previous history, relationships, activities, and there has to be the opportunity to determine intent. Now, as I have said at previous meetings here when we discussed biometrics, the intention is not to spy on citizens of our own countries or other countries. The intention is to use the means that are available to us, again, respecting the dignity of individuals, to attempt to determine intent. Unfortunately, most of these types of things that we have done in the past have been forensics, try to determine what a person's intent was because they committed a particular act. As people now gain access to our countries, as people now have the type of capabilities that Walter has mentioned, where you can, as a single person or a small group of people, affect tremendous damage on the security of both of our nations, it's imperative to have some understanding of the intent and the associations and relationships of the people that are trying to seek permanent residency on our shores, and certainly, as we do to some extent, for the people that just wish to come and conduct business on our shores. This just, as the times change, the nature of the threat has changed, and we have to have different ways of monitoring the people that are coming to our nations and trying to determine the true intent of those people coming to our nations.
Thank you very much. Ms. Tsitsabayisin.
Thank you. I'd like to thank all of our witnesses for joining us again today. To further your comments, Mr. Platsis and Mr. Purchell, I too am a child of immigrants, and I'm actually the case of the young child who only truly knows Canada as her only home or safe home. So the safety and security of Canadians and our communities is a priority of mine and is a priority of the NDP. Earlier this month, I co-hosted a community conversation on safety where the leader of the official opposition attended, and he took lots of questions from members of my community in Scarborough, or from residents in Scarborough. Immigration, it didn't come up, as we know, and as you mentioned, Mr. Platsis. The vast majority of newcomers to Canada are law-abiding people who don't commit crimes. Actually, when people are talking to me about immigration issues, it's generally constituents who are looking for fairer treatment, a speedier reunification with their families, like you mentioned, Mr. or Admiral. What we did hear from residents of Scarborough was the need for preventative strategies and giving law enforcement the resources they need to keep us safe from criminals of all backgrounds, whether they're citizens or not, just to keep the community safe from criminals. We've also been hearing from witnesses in these committee meetings here that the government needs to address the lack of training, resources, and integration of information and monitoring technologies within the responsible public service agencies. From witnesses, as well, of course, we all know from Auditors General reports time and time again. I'd like to give you an example. Serious errors appear to also lead to the delays in removing serious criminals, like Clinton Gale. Lost files, human error, lack of detention after violating terms and conditions of release have occurred in some of the cases used as examples by this government. How can the current system be improved without eliminating an individual's right to due process? Like you mentioned, every person should have their day in court. So how can the current system be improved without eliminating a person's right to due process? Any one of you can answer my questions.
If I may, I can start on that. I think one of the traps that we often get caught in, particularly in the context of our time, which is a very complex time with many issues, is we tend to institutionalize silos. This is a problem that we've spent a great deal of time thinking about. And what silos do by nature is they develop their own cultures, their own resources, and their own informations. And what they fail to do is they fail to share that information across, which would leverage the capacity to understand the problem in a better way. The problem of potential criminality is not limited to law enforcement.
When you say institutional, sorry to interrupt, I just want to make sure I'm understanding you. When you say institutionalized silos, what do you mean?
For example, a police agency has a particular way of looking at the world. And that's a function of their experience, the way they see the world, the clients they deal with, the population that they have.
So the different agencies working in silos rather than being integrating. Okay, thank you.
So the problem of crime is in your riding or anyone else's in Canada is not simply a function of a local police force. It may or may not be associated to an immigration issue. It may or may not be associated to a multiplicity of issues. A bad, poor quality education, which is one of the things that came up. That tends to really say that what we really need to do is develop holistic approaches. And certainly in the matter of people coming into our country, I think that's what we've been really pushing towards, the holistic approach. A holistic approach that starts as far forward of Canada's borders as possible. A holistic approach based on information that gives us information on a forward base and leads all the way back to the community where this person ends up residing as a landed immigrant, as a refugee, as a whatever. We want to know, as I indicated in my earlier remarks, and I think we have a right to know, as the people who are resident here, who's in our house. We have a right to know who they are, what their background is, but we need resources that come from a multiple number of agencies, not a single agency.
Right.
There is a great challenge here, however, because we have not developed as yet an integrated and secure system that shares information.
Okay, so you're saying similarly to what the Auditors General reports have been saying is ensuring integration of resources
Clearly,
within CIC.
but that balance...
I just have one more question. I only have 2 more minutes left, so that's why I'm trying to rush through.
Indeed.
I really apologize for cutting you off a little bit there. But during a federal inquiry about the same case I mentioned earlier, the Clinton Gale case, the Associate Deputy Minister Ian Glenn stated, and I quote, "Quite simply, the system failed," end quote. As to why, he explained that the department's priority at the time was to target unsuccessful refugee claimants who were on the run rather than criminals, because that way the deportation numbers would be higher. How is this policy effective at keeping Canadians safe from serious criminals who are not citizens? George, Mr. Platsis? Anybody?
I'm still trying to find your connect here with your quote and that policy.
Well, I'm just taking it based on his explanation of following his quote was that they were trying to get numbers high of deportations. They weren't focusing on criminals. They were focusing on deportations at the time of unsuccessful refugee claimants. How's that effective policy?
I'm not going to comment on that specific case because I don't know that case well, but I'm going to turn it back to the comments that Walter was making here, that I think what the policy is trying to at least lead to is the integration of agencies and push forward what sort of information we have about people to make informed decisions, to echo the Auditor General.
Sorry, I want to see if any one of the other ones maybe want to answer the second question.
Better let him finish because all you got is 15 seconds left.
I'm
Go ahead, sir.
willing to let it go.
Guess we're going to move on to Mr. Lamoureux.
I want to think in terms of if this bill passes, it will have profound impact on a lot of people. Hundreds of thousands of people every year fill out documents, paperwork from overseas. There is absolutely no doubt that there is misrepresentation that occurs. A lot of it is intentional, where you have someone trying to intentionally mislead the Government of Canada. But equally, there is a considerable amount of it that's done unintentionally, maybe through a representative or just an innocent mistake. Now, in those situations, we're not talking about a few, we're talking about hundreds, maybe even into the thousands, where it's unintentionally done. we're increasing the penalty. We're saying from 2 years to 5 years that you're not going to be able to apply in order to come to Canada. Does that seem to be fair for those individuals, and we're not talking hundreds, we're talking thousands, that that there is no system in place that would allow them the opportunity to explain why it was an accident, and those do happen. Those happen in Canada in filling out all different types of forms. Is that a piece or a part of the legislation that you think that should be changed to take into consideration of misrepresentation where it's not done intentionally?
Of what you would consider unintentional, and I can depart from there.
Sure. Let's say, for example, a gentleman finds a young lady and he marries the young lady in another country. In the form, he's asked, well, where did you work and where did you go get your education? So he inadvertently forgets that he worked part-time at some facility, puts down his education, he listed other things, but he didn't put down where it is that he worked for 4 months on a part-time basis. Because of that misrepresentation, he's not able to apply for 5 years. So they're going to be separated as a spousal. There are hundreds of examples of that sort of nature. Is it fair to increase from 2 years to 5 years?
With respect, I wouldn't know if that was unintentional, and I'm going to give my own case. When I lived in the United States, I had to go through a similar process where I had to give my history, I had to fill out all the forms, and I think there's onus on the person to actually make sure not only to double, but to triple and quadruple check. And someone coming into Canada, or in my case, when I was living in the United States, it's not my right to live in another country. You know, I am a guest in someone else's home, and I think the onus is on me to make sure that my information is correct. Do honest mistakes happen? Yes, I'm not sure forgetting to work, listing that you were working somewhere for 4 months would, in my own opinion, would constitute an honest mistake.
Yeah. And, you know, and we're entitled to agree to disagree.
Absolutely.
I talk to hundreds of immigrants every year and witness firsthand what I would classify as innocent mistakes, and I don't believe that we should be punishing them excessively, and that's one of the reasons why I think it's important to see an amendment of that nature. Equally, I've used an example, and the example I used earlier was actually presented to the committee from a former chair of the Immigration Division of the Canadian Bar Association, talking about a youth that's 19 years old, that's a landed immigrant here in Canada, graduates, crosses the border, uses a false document, and as a result is going to be deported. Unless, of course, the ultimate appeal is that the Minister of Immigration could say yes, but so much for the rule of law or quasi-judicial system that would ensure that there would be a protection, because that principle could apply for any and virtually all cases, period. There seems to be a fundamental flaw in the fact that at the end of the day, I believe most Canadians would see that as something that doesn't warrant being deported and not having the opportunity to have an appeal because someone used false identifications in order to get served alcohol at age 19, 20 when they were 5 years old when they came to Canada. Would you not agree with that?
Respectfully, I would say you're using false identification. And if someone that has come here at an age, to use your example, of 5 years old, and has lived the majority of their life in Canada, I think they're relatively conscious about what their decision is to use fake ID. Now, if you're saying that it's disproportionate, again, when you're going into another country, with respect, I think you have to respect and value their own laws. You are a guest within their own country. And do you want to jump in?
If I may, I would leave penalty to lawmakers, and you are lawmakers. I think you've opened a far more difficult problem, and certainly one that I'm going to give some thought to. How do you separate intentionality? You have indicated that the vast majority of issues on intentionality are intentional. It is the minority that are not intentional. How do you do that? And one of the things that we could do, and again, I believe in protecting the House as far forward an offense as possible. One of the things we could do is something that to date we've chosen not to do. I believe, personal view only, we should have a foreign intelligence service. because we should have somebody that sits there and checks the form. And then that can be reviewed in an embassy and can be discussed by an immigration officer at an embassy in a foreign country before it ever becomes an issue that contacts us here in Canada.
We have to move on, sir. Mr. Menengakis.
Chair, and thank you to our witnesses, and thank you once again for joining us. Like a lot of my other colleagues here, I too am a product of immigrant parents. My parents came here from two very poor villages from Greece. We're talking about a bill today. I've heard the word immigrants thrown out, unfortunately. It's not a bill designed to keep immigrants out. It's a bill designed to faster remove foreign criminals from our country. My parents, like all immigrants, were, well, like most, came here with a dream. They worked very, very hard. And I'll never forget, one of the most poignant moments in my life was the day that I was sworn in as a member of Parliament with 34, 35 people in the room. And there was my dad sitting in the front while everybody else was smiling and taking pictures, and he had tears streaming down his face. This is not a bill designed to go after parents like mine, law-abiding citizens who came here and worked hard, helped build this nation, and grow families to be contributing citizens in this country. It's designed to keep people like Clinton Gale out. And I don't want to be flippant about discussing the case of Clinton Gale, because here was a foreign criminal, a drug dealer, known, who shot down and killed Todd Bayless, a young police officer, 24 years of age, the prime of his life, engaged to be married to a beautiful young lady, and whose parents and that young lady and people that loved him are still feeling that pain today. Now, Mr. Gale was in the country, unfortunately, because he had an appeal process. And while his case was being appealed, he decided to perpetuate more crime. Here's my question. My first question is this. Todd Bayless died at the hands of someone that was a known criminal. And since he wasn't removed from Canada, he continued to live that life. Do you think that known criminals should have a right to an appeal process? Foreign criminals. Question.
Is this the question of the serious criminality? Yeah. In this case,
yes,
my own opinion, no. They have a long list of history, and as I have mentioned, and the cases that have been presented, you have cases of assault, sexual assault, fraud, drug trafficking, weapons charges. We should really ask ourselves, are these the people that we want in Canada? Again, I'm going to go to my own case. When I was living in another country, I am a guest in that home. When someone comes to our country, they're a guest in our home, and I think it is a reasonable expectation that they respect our values, our laws, and as a guest, if they're breaking these laws, especially on such charges of assault and repeated assault and multiple assault, the resources that we're using for their appeal and then for keeping them in a detention center or into the federal prison system, these are resources that we are diverting away that we could be actually using for immigrants and refugees that actually need them. Anything from education so they could integrate faster into the country to helping them find a job. An issue like that, I see it, and I don't know what the cost of the entire appeal would be. That takes resources away from people that have legitimate use for them.
Thank you. I might add, last week was a constituency week, so all of us parliamentarians were back in our ridings. And let me just say, your response is something that was echoed in the many meetings I had with constituents in my great riding of Richmond Hill, almost to a person, irrespective of political party affiliation. Everyone had the same opinion. criminals, foreign criminals, should be removed from this country as soon as we identify that they're criminals. Mr. Pershaw, I see that you...
If I may, but again, I don't want to beat this to death, but I think it's an important point. We need to know who these people are before they get here.
Exactly.
And you know, there are some simple things that can be done and more elaborate things that can be done, but really, the time to know about somebody coming into your house is before you let them through the door. So let's think or give consideration to, I would respectfully submit, the idea of, again, finding out about people before they land. If somebody shows up at a Canadian airport and now has no documents because they are now in the toilet of the airplane, what we should do is a simple measure. We should ask that an electronic copy of the documents that they boarded with be sent to Canada first. This is electronic data transfer. It's simple.
Yeah.
And if they now show up and claim, I don't know, and I've lost my name, and I'm actually somebody else, well, you came on this thing. This thing says, because we've checked with an appropriate authority, Canadian or otherwise, says that you're a criminal, and you have one of two choices, incarceration or deportation. And that is $50,000 of appeals done in 15 seconds. There are efficiencies to be had here, but the critical variable, respectfully, sir, is we do not have sufficient information about the people that are coming into our house. This is a real concern for all of us.
Let me offer you this as I'm running down. I'm sure I only have about 15 seconds left. Is that right, Mr. Chair? About that? One of the things under consideration right now, as a result of discussions we've had with the United States in the Perimeter Security Agreement, is the implementation of the electronic transfer travel authorization, the electronic travel authorization, the ETA, which does precisely that. It's someone will have to fill that documentation to be checked out prior to embarking, getting on that airplane or by land to enter into our country.
Absolutely.
So we'll identify them up front. So I'm really, really pleased that you brought that up. Thank you very much.
Thank you. Ms. Freeman.
Thank you, Mr. Chair. So I want to thank our witnesses for being back again, seen each other a few times, and we're always glad to have you. I want to talk about the reports from the Auditor General. Chapter 7 of the 2008 Auditor General Report on removals and detentions states that detention decisions are inconsistent. Section 7.27 states that, quote, while requiring a financial guarantee helps ensure that individuals comply with requirements, we found that the agency does not analyze the extent to which individuals comply with the terms and conditions of their release, nor has the agency set standards or guidelines to determine whether the level of noncompliance results is undue risk to the public. While infrequent, there have been cases where individuals who have been released on condition committed violent crimes. End quote. Would a review of compliance help to prevent individuals who have been released from committing a serious crime or reoffending? Any of you?
The evidence is that there is noncompliance. I think we've got a lot of people running around that we've lost track of. That's clearly within the public domain. We have tens of thousands of people that we had asked to appear or that shouldn't be here at all or are here illegally or otherwise that we have no capacity to manage or identify. We know that. This is part of the issue that we're trying to sensitize you to from our perspective. What we're trying to do is find out before, not after, because very clearly the after part is not working very well. And again, if that number is in fact what the government has indicated in the tens of thousands, then we failed rather badly.
If I may, compliance is obviously a very difficult subject, whether it be in the workplace or in the government. Of course, review of compliance is imperative if you have a set of instructions and directives that one must comply with. And so no one would ever argue that compliance is not a prerequisite into an effectively operating function. The question really is, from a legislative body, can you legislate compliance? And the question becomes, what is it you want a law like C-43 to do? What is it you want your immigration system to do? Why do you want immigrants to come to Canada? In the United States, I would suspect it's the purpose of an immigration system is to protect the United States and its citizens in accordance with the Constitution, and 2 is to make the United States a better place by bringing in people that give us diversity and strength and capability and make us a better nation. And so the things you as legislators must do is ensure that our policies are in place to provide the agencies, whether they be federal or state or local, with the tools and the resources to be able to carry out those policies and effectively comply with the intent and the purpose of the law, which is, in the case of the United States, to protect the United States and make the United States better. And so it's very difficult to get down and really deal with each of the eaches. Not that my own Congress doesn't attempt to do that frequently, and not that that might not be warranted in some instances.
Yeah, but I mean, if we're talking about a lack of coordination of resources, of coordinating efforts, of training, I mean, I think we've heard a lot of extreme cases to justify this law. And a lot of those cases came down to bad coordination, bad technicalities, where these people ended up staying in this country based on technicalities, were able to appeal based on technicalities. That's not a question of needing stronger laws. That's a question of needing better resources. Would you agree? And Mr. Platsis, I'd also like you to jump in.
I think, again, that the question goes back to having the right information about people coming in. I think the cases, you could argue that both cases for and against have been extreme. Like, for example, a case that the marijuana plants, for example, that I used, I think that's an extreme case. I think that doesn't pop up too often. And the difficulty with compliance, to echo the Admiral's comments, is compliance is a very difficult thing. I'm not sure if you can actually legislate compliance, but what exactly are you doing? Because compliance, by virtue of what it is, it's reactionary. You set out what you want to comply, and then you go back and you check against. Mm-hmm. And I think that's going contrary to what we've been trying to say, that it's not taking into account what is happening today and tomorrow. And I think we really need to focus on today and tomorrow, and to see what sort of vision we want for Canada, and what we want the immigration system to do, and in the larger part, what that immigration system fits into the larger Canadian interest.
And just to
You know what,
specify.
Ms. Freeman, I'm sorry, our time has expired.
Aw.
I know. And you know, we probably could go on for quite a while. You've raised some great points to all sides, and I'd like to thank our witnesses for coming and making your presentations to us. Thank you very much. Before I adjourn the meeting, we will have 1 hour of C-143 tomorrow, and then, Ms. Freeman, order. And then we will have 1 hour of supplementary estimates. The minister will come for the final hour from 4:30.
It's Wednesday.
On Wednesday, yes. Oh, yeah, I've really messed it up, haven't I? I meant Wednesday, just so you all know. Tomorrow morning is C-145.
45.
45. It's been a great day. The meeting is adjourned before I mess up some more.